All right, hi everyone, welcome back. So today we have again two tables, similar faces. Very nice to meet everyone again. Now, today we're going to look at the new topic. We'll continue where we left off, where we're looking at actual offenses against people. So today we're going to look at sexual offenses in line with what our faculty has done as well. So here's the lesson outline for today. There are a few sexual offenses that will be tested, just like last week. If you remember from last week, we look at common law offenses, battery, assault, we look at in the statute. So in our case, sexual offenses, there are mainly 4 of them that you need to know. First of all, it's rape under section 38, all right? And then we're going to look at related offenses. We have section 43, which is a threat to commit sexual offense. Section 45, procuring sexual act by fraud. Section 40, sexual assault. And then we'll look at practice question 3 from LSS. Finally, we will do a Q&A together. Okay. Now, before we proceed further, I do want to note this when we talk about sexual offenses as well, because unlike other topics, this topic do come up as upsetting towards some students, all right? And even for me myself, I'm doing criminal law 2 at the moment right now, and there are some of the most ridiculous offenses when it comes to murders, drugs, all sorts of things. But sexual offense is one of them. So if you do get upset along any moment, just feel free to take a break. Okay, if you want to go to the toilet or anything, let me know. And when you read your faculty slides as well, same thing applies. There are some support on the slides as well. Okay. Anyway, so that's the schedule we have, and we're looking at topic sexual offenses, topic 5 right now. Today we'll be doing practice questions 3. Okay, question 2, if you have done that yourself, you can send me an email or anything like that. I'm happy to look through as well, not a problem. Okay, so first, the most fundamental thing when it comes to sexual offense, I think most of us will think of it as rape. Okay, so this is under section 38 of the Crimes Act. Section 38 of the Crimes Act. If you are not too sure all these legislations, go and read through the Crimes Act. So I'm going to break down the actus reus and the mens rea of rape, and after that, hopefully you'll be able to apply the same to other related offenses, and we'll look at practice questions together. But anyway, here are some of the elements, okay, or the things that is being involved in rape, and some of the things that you need to fulfill. So first of all, whenever you look at rape itself, you want to look at the Crimes Act, section 38 of the Crimes Act. Okay, if you are being massively penetrated, looking at section 39, but usually it doesn't arise from the facts on the exam. So for rape to occur, you need to first of all you need to have some sort of sexual penetration. And sexual penetration, if you think of it in its very traditional sense, in many other jurisdictions as well, but in Victoria, Australia, there are also a few other ways where sexual penetration can occur, but this usually wouldn't be contentious in your exam anyway. As long as you see some sort of penetration and it fits the criteria set out in section 35A, then there will be rape, there will be sexual penetration, sorry. Now, another form of actus reus is you need the lack of the complainant's consent. So there must be sexual penetration without consent. And this is when most of these things get a little bit iffy-murphy. For example, two person, one guy, one girl, they went on a party, and then maybe he got drunk, and then maybe the guy thought he got consent from the girl and penetrated her, for example. Would that fall under consent? So these are all issues that we will be looking at under this part, and that's when most of your exam questions will be contentious on this part as well. There are some case laws to support this. One of them is Question of Law number 1 of 1993. That's one of the cases that is in your reading guide as well, I believe. And then another important issue that might arise is mistaken of identity, or sometimes deception or mistaken consent. Maybe you thought that maybe you thought that the other party gave you consent, but did he or she, right? That's one question. Sometimes maybe are in clearance, right? Sometimes you might have thought that maybe you had a sexual penetration with another person. You thought it was maybe a person who gave you consent but didn't happen. Or maybe crown and linker, where you have sexual intercourse with a prostitute, okay, and then you didn't pay the prostitute in the end. That could be considered rape. And that's also what we look at in our practice question 2, actually, where the person went on to have a sexual act with a prostitute, and then later on didn't pay the prostitute when he agreed to pay. Later on, in Linker's case, basically what she did was she alleged rape, but in that case, it was held that there was no rape because the complainant understood the sexual nature of the conduct. So these are all things of the cases that you will look at. Now, so far we've looked at the Crimes Act for quite a fair bit, but there are also another act that will be involved this week, which is the Jury Directions Act, or what we call JDA. Who here has been involved? I'm sure all of you are over 18, yeah? Anyone under 18 so far? No? Has anyone been called for jury duty before? I thought that's going to be a hand here. No? No? All right. So, but who sort of have an idea of what jury duty involves? Say, for example, myself, when I was doing my foundations of law, I went to the court, I looked at the murder case, and then there was like jury, there was like 2 rows of 6 people, and they were like question 1, question 2. That's what basically what jury is. So the Jury Directions Act basically tell people about some of the law surrounding rape or any other offences to the jury. Basically, it allows of the judge to tell the jury what is the law. Okay, what can they say? What can they not say? So people just like you guys, you can get called to be on jury duty any day as long as you're over 18. So that maybe after this class you receive an email, who knows? All right, so we'll look at Jury Directions Act. And finally, we'll look at common law presumptions, which is being abolished, so you don't really have to worry too much about that. Now, let's look at the legislation. All right, so I'm just going to show you everything. So this is under section 38. I've changed them into pink and orange, so I'm going to explain what those are. So let's look at this. Person A commits an offense if A intentionally sexually penetrates another person B, and B does not consent to the penetrator, and A does not reasonably believe that B consents to the penetration. Okay, then A will be guilty of rape. So let's look at some of the actus reus. First of all, we have sexually penetrates. That's the actus reus. Look at the section 35. Look at B. B does not consent to the penetration, lack of consent. So under your big headings, you'll be like sexual penetration, lack of consent. Then you look at the case law. And then you look at mens rea. First of all, there must be intention. Okay, the question is it intention to sexually penetrate or intention to rape? Would that be an issue here? Intention to sexually penetrate or intention to rape? Intention, do we know the difference in what I'm asking? Like one of which is you intentionally did the act of penetration. The other one is you intentionally wanted to rape someone. Not a big issue because like it's not that contentious. So we usually just look at it as intention to sexually penetrate. Yeah. And then A does not reasonably believe that B consents to the penetration. Is this an objective or subjective test? Anyone here? Subjective test. A does not reasonably believe. Objective test, yeah. Reasonably, okay. Anyone else think it's subjective? Not really. So what happens is that under 1C is an objective test in the sense that it's reasonable belief, and under 1A there is a subjective test of intentionality. Okay, so in my exam, how would I structure my answer? Very simple. I would be like, first of all, I will be like the issue, and I will be like, is there rape under section 38? Okay, And then after I've done that, am I writing too small? Can you guys see at the back? Yeah. All right. And then after that, I will talk about the actus reus. That will be like element 1. There will be a sexual penetration. Okay. And then once I'm done with that, I will link to what the definition of sexual penetration is. This is defined under 35A. And once I'm done with this, I will apply the facts. Usually this will be made up, right? Usually there will be penetration. It doesn't have to be the strict sense where a guy just penetrates a girl. It could be like using any sort of body. We'll look at the specific legislation later. And then we have element 2. Okay, the lack of consent. This is when you look at section 36.2, where it defines section 36.2 and section 36.1. Okay, this is where you define what the consent is. Consent is the lack of free will. We will discuss all this in a bit of time. But I'm just going to give you the big picture so far. And once we're done with this, then we look at, and obviously you could add in case law as well. For example, in the practice question 2, we talk about a guy, we talk about the guy going to see a prostitute and in the end did not pay the prostitute and left. Was there rape? Is there consent? And then you could use, say, for example, Crown and Vickers case and be like, oh, no, because the complainant didn't understood the sexual nature of the act, so therefore it's consent. And then you combine the legislation. You could also incorporate a little bit of jury direction as well. Jury direction. Act. This is like the easiest way to get 20 out of 20 for your sexual offense questions. Very simple. As long as you incorporate all this, you do the checklist and you apply to the facts, you will be able to do a very good job here. Okay, and then once we're done with this, what we do is we move on to the mens rea. Mens rea is a subjective and objective test. So first of all, we have the subjective test of the intentionality under section 38(1)(a). Okay, this is usually not contentious. Yeah, if I want to do this action, I do this action. It's not like offenses against the person where maybe you wanted to just punch the person for eating road in class, and then in the end you cause serious injury. Just keep eating, I don't mind though. Okay, anyway, you know, like that is when it's contentious. But it might be, it's not contentious here on the facts if you are just doing the action of sexual penetration. So this won't be an issue. Then we have the objective element. Okay. Section 38, 1C. Right. So we have the objective test. This is when you make use of a bit of your legislation. You could do a bit of jury directions as well. And then you conclude. Based on all this, you could do a bit of case law, and then you conclude. So this will be about 7 marks in your exams, I would say, out of a 20-mark question. You will obviously have other issues let's say, is that procuring sexual act by fraud, try to commit sexual offense, sexual assault. Because usually in every sexual offense question, there will be certain sort of penetration, but there will also be other related actions like touching, and the nature of the touching is sexual in nature. Then it does not fall under penetration, but falls under section 40, for example, for sexual assault. So these are all things that you need to consider. All right. So first of all, we have the first actus reus element 1, sexual penetration. I'll talk about that. Basically, A sexually penetrates B if A introduces any part to any extent of A's body into B's vagina. So this could include anything, right? It could include, like, as long as it's any body part, it will satisfy. Again, any part into B's anus, that will be considered as well, or B's mouth, there will be penetration as well. And then sometimes you have this idea of A having introduced part of A's body or an object, okay, into B's vagina, continues to keep it in there. Sounds a bit like Fagan, isn't it? And then, and that would fall under section 35 as well. So this is not hard to understand, and it will be made out in the exam most of the time. So just understand this basic principle, and then we'll move on. But you have to quote section 35A, subsection 1. All right. Now, this is a little bit more interesting, the lack of consent. And this is when the bulk of your marks will be going to. So for example, if I have a rape question, this part, sexual offense question and rape, maybe the rape part is worth 8 marks, I might give up to 3 or 4 marks for just discussion of consent. Because there's just so much, if you look at so much legislation, so much case law, so much jury directions act that have to be discussed. So when we look at this, the first step we have to do is we have to say consent. What is consent? Defined under subsection 1. What is subsection 1 say, anyone? What does subsection 1 say? What does consent mean? Consent is very good, very good. And subsection 2 tells us that certain circumstances, okay, in which a person cannot consent. So there are a few examples. So for example, if you went to D1 this Friday night and you drink a lot of alcohol, maybe you see a girl that's drinking a lot of alcohol and she's drunk, and then you say, wait a minute, she consented to me. Then section 36(2)(e) tells us it's incapable, okay, of consent. If you unlawfully detain someone, there's no consent. If the person is asleep, there's no consent. If the person is mistaken about the sexual nature of the act, there's no consent. Maybe, for example, if you're telling them, you're going for a massage, I don't know what other nonsense that could be, and then for some reason there's some sort of penetration, or maybe you went to a doctor and the doctor put your hand. Maybe he was checking you for some things, and the doctor inserted his finger into, then this H will be relevant. Oh yeah, J will be relevant. Mistakenly believed that act is for medical purposes or hygienic purposes. Yeah, so sometimes in the practice question, you will see the person does not say anything or do anything to indicate consent. There was a past question that I did before when the question was set along the lines where V froze, the victim froze, she did not know what's happening, and she did not do anything, and then the D is arguing that, oh yeah, because she didn't do anything, therefore there is consent. And then 36(3) subsection 2(I) will tell us there's no consent. Okay. I'm just going to, there are a few issues or case laws that could be applied throughout your exam. I'm just going to give you a few cases. By no means are these comprehensive. Ideally, you want to read all the cases and come up with your own version as well. But let's look at a few issues. First issue is, can there be consent when there is rougher than usual handling? This sounds quite similar to the case when we first started, isn't it? So this is a question of law number 1, where the husband was acquitted on charges of rape and attempted rape of his wife. There were 2 questions of law, right? Is it possible, to get this consent by measure of rougher than usual handling? Okay, because I think the judge says there is nothing wrong with the husband faced with his wife's initial refusal to engage in sexual intercourse in attempting in an acceptable way to persuade her to change her mind, and this involves rougher than usual handling. Okay, so and then it went on appeal. Went on appeal. Okay. Went on appeal, and what happened was Justice Perry said that the law is clear that consent must be freely given. Okay. The difference between submission and consent can be a fine line. So what happened in the end? I'm just going to give you guys 1 minute to read through this, and then I'm going to move on. and what happens, it has never been the law that consent might be induced by force against the will of the victim. Okay, looking at this matter in that way, the direction that involved an error of law. So on appeal, Justice Perry said the initial trial judge was wrong. Actually, this is kind of under legislation as well, 36.2, if you look at those sections. But it would be nice if you quote 36.2 and at the same time you quote a little bit of case law. The tutors would be like, oh, good, then you get the marks. Okay, so, but if you just do these two, it's still not enough. You still want to talk about jury directions, which I'll go to in a moment. There are a few other things where can there be consent when V only consented to disease-free sex? Just going to give you the answer over here. You can read through the slides yourself. Right, because V in that case did not misunderstood the sexual nature of the act or these identities, so the infection does not cancel out consent. So for example, if two person, husband and wife, they wanted sex or maybe other things, okay, and then because maybe V got infected with the disease, that does not cancel there might be other offenses, but that does not cancel the consent on itself. Okay. Same thing, Crown and Linker. This was about the prostitute case. The defendant arranged to have sexual intercourse with a prostitute for a sum of £25. Okay, the defendant did not have money and he had sexual intercourse without paying. We claim that she had been raped later on. So can there be rape? Okay, and the answer to this question again is that because the existence of fraud on the perpetrator part does not mean there was a lack of consent and the perpetrator is not guilty of rape. Okay. Seems a bit weird, right? Isn't that? But there was a separate offense for this section 45, procuring sexual act by fraud. Okay, so therefore, even if this is absurd to you, thinking that hey, you wanted to pay a prostitute, you didn't pay, blah blah blah. That would be section 45. That wouldn't be here because the penalty for these two is a little bit different. So what happens if you see a question like this in your exam, 20 marks? Do you just go to 45 right away? If I give you a problem scenario, say LSS practice question 2, okay, I'd be like, one person went to see a prostitute and then later on did not pay, and then discuss the criminal liability for 20 marks. Exam technique. What would you do? Would you go to rape right away? Or would you go to section 45 right away? Or would you discuss a little bit of rape? What do you think?
Yeah, you do rape and then see that it's not satisfied, then you move on.
Yes, very good. Right, so you still do everything over here and then you go to 45. Because if you do everything over here, you get 10 marks first, and you go to 45, you get 10 more marks. If you just go to 45, yes, you kind of get the right answer in the end, but you pat yourself at half of the marks available for that question, which is not that ideal. So that's pretty much a law technique. Same thing I see if you're working on your law assignment, I still don't know what the law assignment is, but I kind of know it's a problem scenario. Same thing, okay, if you do see some questions where you think something obviously doesn't make out, okay, but kind of is somewhat related, where there are case laws, where there are places to show the law knowledge, you still want to acknowledge it, but dismiss it and then move on to the actual and then make a conclusion. All right. Then after you've done everything, actus reus, you're still not getting full marks for actus reus. Why? Because you still have this part on Jury Directions Act. Oh goodness. Jury directions. So I'm just going to explain this a little bit. And this is quite confusing when I first started learning. So if there are anyone who has any sort of questions, I'm going to pause the class a little bit after I explain this, and you guys can explain too. I can explain a little bit more. Okay, so the question over here is that after you've done everything 36.2, 36.1 case law, then the prosecutor or even the defendant or the defense team, but they wouldn't do that basically. I may request the trial judge to direct the jury on consent under Section 32H of the Jury Directions Act. Okay, and then given that whatever blah 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 happened, the prosecutor may require the trial judge to inform the jury that whatever, quote from Section 46(3) of the Jury Directions Act. Okay, so what happens is that, for example, in your case that involves the victim did not say or do anything to indicate consent, so you will quote Section 36(2)(I) in the sense where there is no consent. But who is deciding whether or not the defendant is guilty? The trial judge or the jury? Yeah, jury. Do the jury know the law? Probably not. I mean, if you get caught in the jury, you will know the law, but not a lot of people, they won't know the law. So the Jury Directions Act, you want to, prosecutor will involve, you will tell the trial judge to inform the jury that Section 36(2)(I) exists, and this power is from Section 46(3) of the Jury Directions Act. Clear? All right, that side is clear, this side? Clear? So if you miss out this one, you're going to lose marks in the exams. Okay, it might seem whatever stupid to you or whatever other things you want to call it, but you just have to do it in the exam setting. Okay, now, these are some of the common directions. Okay, 46. Sorry, let me just check that. Yeah. So direction on consent under 46. And then, okay, these are some of the things that could be directed to jury. For example, the prosecution or defense counsel may request the trial judge to inform that, okay, consent is a free choice under Section 36(1), subsection 1, sorry. And this power is given by 46(3)(a). Okay. And then it might be under 46(3), under subsection 4. Okay, you may request the trial judge, blah blah blah. Relevant circumstances, consent, Crimes Act, 36, whatever. You go and read through this and you see what is relevant and you pull it out for your exam. Okay. Now we're going to look at mens before that. Any questions? No questions. Okay. Now we're going to look at the mens rea of rape. So intention. Intention is pretty trivial. It's not contentious at all. What's contentious? You still discuss that, but you just say, oh, it's made up, one sentence. Okay. Now, what's contentious is the reasonable belief that V consents. Okay, so under the circumstances that D faced, would D reasonably have believed that D consent? Okay, so what the prosecution need to prove is the lack of reasonable belief. So reasonable belief is in consent defined in Section 36(a). Okay, we're going to look at that, and there's some case law as well. The reasonable belief is an objective element, but not wholly objective. So so that I think there was like what they call this an objective and subjective test. Okay. Because it still says did not believe. I guess the belief is subjective, the reasonable is objective. So you might want to phrase this as a subjective plus objective test. I'm going to leave the rest to you guys to read through the case law, but I'm going to highlight the jury directions again. So if you want to raise a direction under JDA, you're looking at Section 47(1) on reasonable belief in consent. Okay, then there will be like one or more of the directions set out. But you could still argue a lot of those facts as well. These are some of the directions that could be given. I'm just going to give you guys maybe 2 minutes to read through. If you do have any questions, let me know. If not, I'm going to move on to other offenses. Okay. So what's most important over here? I think I would take into account of personal attribute characteristics or circumstance of the accused. I think that's most important. All right. And then if you do see situations where there was intoxication, you see whether the intoxication was self-induced or not, for example. And then others, right? If there's some sort of bias, okay, or value, you go and check religion, right? You want to look at that as well. But this section is best if you look at it yourself. Again, like what I say, I'm giving you a big picture on how to solve these kind of questions. All right, that's pretty much rape. So that's pretty much rape. I'm just going to tell you what are some of the other offenses, but I really want you to go and take time to look at them yourself. Question? No? Okay, I thought you were pointing. All right. So there are a few related offenses, but mainly, I'm just going to write them on the board first. What you have is you have section 40, sexual assault. This involves a lack of penetration in a sense. There is no inserting into whatever that was discussed in 35. But if you do see, like, say, for example, touching, and the touching is sexual in nature, and the person seeks pleasure, sexual pleasure from touching, it falls under 40, sorry. And then you have section 43, try to commit a sexual offense. I think in last week's practice question, there was some sort of threat like, be my lover or you will never be in law school again or something like that. Right? So it could be fallen under section 21, threat to commit a serious injury. But it could also fall under section 43, like I explained to some of you last week as well. So this involves making of a statement. And then we have section 45, procuring sexual act by fraud. For example, if one of you says to another person, okay, if you conduct a sexual act with me, I'll pay you £100. Or maybe a law professor speaks to someone and be like, oh, if you have sexual act with me, I will give you 100 of 100 for criminal law, like whatever things. And it was like fraud, and you didn't do it in the end. Okay, that's 45. The rest of them, I will leave them to you in the, I'll just leave that to you to explore under the slides yourself, or if you have questions, you can come to me after that as well, after class. Okay. Any questions with relation to the other three offenses? No? All right. In that case, we'll be looking at the practice question today. Okay. So we're looking at question 3 of the LSS sketch notes. I hope it's not too small, but if it's too small, you can look at that from your own laptop as well. By the way, these questions will be related in the next 2 weeks as well. So question 3 will be sexual offense, and then with the same scenario, and then I wrote a completely different story to this Rosie and Harry situation. It will be for murder and manslaughter, and then it will be for defenses basically. But anyway, yeah, just give you guys maybe 5 minutes to read through and plan the answer, and then we'll go through that in a moment. All right, shall we go through this question? By the way, did that table figure out the last offense? This table figure it out, or was it? Threat to commit sexual offense, very good. All right, so what happens for this question? Pretty simple, 20 marks. I will be talking about rape as a big heading first. And then I will talk about the threat to commit a sexual offense. And then I'll talk about sexual assault for 20 marks, okay? This is very difficult in a sense. If you don't know the exam technique, you'll be looking at 2-hour lectures and you'll be looking at notes in the cases and you don't know how to apply them. And then when it actually comes to writing, you spend 15 minutes writing rape, you did an excellent job and you get 8 out of 20, for example. So issue identification, seeing the big picture is really important. And then we look at the details. That's what I like to do. So first of all, you say there's rape. What was the factual hook for this one? What was the thing that was basically that you thought that was rape? Digital penetration. Okay. Digital penetration. And then you say argument 1, was there sexual penetration? Yes, digital penetration falls under the definition of section 35A, therefore it's been made out. And then you look at B, is there consent? So first of all, section 36(1) tells us consent is free agreement. And then look at factors in 36(2). Okay, so what are some of the factors in 36(2) that points against consent? Anyone? So Harry locked the car door and started to undress all the clothes from Rosie. That looks like certain sort of physical force. Okay, they're all restraining under section 36(2). Are you looking at Rosie froze and was not too sure what to do? Not doing or saying anything does not indicate consent as well, right? And then you could add in a little bit of case law, for example, question of law number 1 of 1993, harsher than usual force. Okay, you could add in a little bit of those as well, and you add in the jury directions on how it operates. And then you look at mens rea. Subjectively, digital penetration, wanted to seek sexual pleasure, therefore intention is made out. Was there reason to believe that there was no consent? He could argue a little bit, but looking at all these facts and okay, looking at all these facts, right? And then not doing anything, and then just okay, frozen, traumatized, probably not, right? So you won't argue that. So that will be your 8 marks. And then you're looking at sexual assault. The factual hook for this is touching of the breast. Okay. Intentionally brushing off against the breast, I think. Yeah. So you're looking at this and you look at the idea that under section 35 that this touching was for sexual pleasure. He could obviously say, oh, he was not intentionally doing that, whatever. But again, it's for sexual pleasure, and you're looking at all the other elements of 40, basically. Threat to commit serious offense. This is basically quotes. As long as you see certain sort of quotes, it's most likely a threat. For example, in this case, no way of getting your license. Unless what? Unless I could touch you anywhere, for example. Touch you. That's a sort of a threat that is being made out. It's a little bit, yeah. Okay, so it's not that hard after all. You see a quote, you do it, and then the rest is just explaining the facts to the question. Yeah, done. Any questions? No? All right, if you have anything, you can feel free to see me as well. But if not, that's all for today. I'll see you guys next week for murder. Bye bye.